What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we're going to take a look at the defendant's motion to amend the verdict slip that was denied by Judge Cannoni. We're going to talk about what the defense wanted to do, whether it makes sense, why Judge Cannoni made the decision she made. Is it going to be an appellate issue? I'm going to answer a bunch of your questions on there. We're going to listen to the 1 minute Judge Cannoni explain kind of what to do with this verdict form as we're looking at the different versions. And then if we have time, later, we're going to listen to Judge Cannoni explain the lesser includeds to the jury and talk about what some of the potential sentences might be for Karen Read, depended on if she is convicted of what individual charge, what she might be looking at. And of course, we're going to have the court stream up in the background. If there's a question or a verdict at some point while we are live, we will go right to court and break it down. I don't expect a verdict today, as we spoke about before, and I'll give you my predictions and when I think we might have a verdict as we go. Let's get into it. All right, so Kelsey, first thing I want to do is let's throw up a poll. When do you think we will have a verdict? Today, Tuesday, so you can go Monday, Tuesday, Wednesday, or next week as our four options, because I've heard reports that there's not going to be any court Thursday or Friday this week. And so that's mind-boggling from the juror's perspective, because they went, 27 hours last time? And I think if they go 27 hours again, it would put us into next week, if not very close to going into next week. Will that affect, any Allen charge or anything that the judge does, anything the lawyers want? All very, very interesting. Not today. They are leaving now. That's what I figured, Crystal. Court will be live at 4:20. Okay, we will jump in there then at 4:20. Yeah, no surprise. And I don't think anybody should freak out about the fact that they don't have a verdict today. Okay, that really is no surprise. And what I kind of thought would be a very average and normal, if it wasn't for the first trial, I didn't expect much to get done on Friday. They deliberate most of the day today. Even if they feel like they are close to a verdict, in a lot of the high-profile trials that we have followed, the jurors have wanted to go home and sleep on whatever their verdict is, especially when it's something so serious involving loss of life, something that is somebody that is accused of something this heinous, possible life sentence that we're looking at, which we'll talk about today. So we will go live with court at 4:20 and see what they say. But they come in, they talk about it today. Maybe even if they've come close to a verdict, they want to sleep on and talk about it tomorrow. So go ahead and throw that poll up before I give my prediction. But while we're waiting for them to get to court, let's take a look at the defense's motion here regarding this verdict slip. And it's an interesting procedure and process, because the law doesn't always do the simplest things. Lawyers commonly make things more complicated than they used to be, or than they need to be, I should say. And lawyers are very slow to make changes. They're very slow to get up with the times. How long it takes something you propose to change a rule to actually become a rule is frustratingly long, even to the lawyers, and sometimes especially to the lawyers. We've got to debate this back and forth, put it up for final reading, edit it one more time. It is so frustrating, and we are so slow to get up with the times. So it shouldn't be a surprise when judges want to stick to the status quo. They don't want to be the one to make the change or the new decision, even though many times that's what's necessary. And that's how we progress in our country. So here we go. Defendant's motion to amend verdict slip. Now comes the defendant, Karen Read, to request that the court modify its jury verdict slip from its current form. Ms. Read submits that the proposed amended verdict slip improves clarity for the jury in understanding its tasks and reporting its verdict. The current verdict slip, particularly the slip for count 2, risk confusing the jury and thus causing errors. Respectfully, the present verdict slip is unclear and otherwise confusing. So here's what I'll say about it. It's not incredibly abnormal to some other verdict slips, but when it comes down to a hung jury on different verdicts, that's where it gets really confusing. That's where it creates a situation where maybe there is a not guilty verdict on one of the main counts and a hung jury on one of the lesser includeds, which would prevent the Commonwealth from trying Karen Read again on one of those higher counts in the future. And that is the situation that we dealt with last trial that the defense is trying to eliminate. This lack of clarity and resultant risk of confusion and error can easily be minimized by tailoring and clarifying the verdict slip to better aid the jury in memorializing its verdict. Indeed, there is no compelling reason not to do so. So I would disagree with the defense here. There is a compelling reason not to do so. The compelling reason is if you're the Commonwealth, you want to argue, we want to try her again. And we want to try her for as serious of a crime as we possibly can. So let's not let the jury check not guilty on any of the other counts in count 2. That's the compelling reason, which is not an appropriate argument. So I don't think we're going to hear anybody make that argument. But that's the only reason I can think of why you wouldn't want to make this change. I guess I should say that reason, and Judge Cannoni doesn't want to upset the apple cart. She doesn't want to do anything new. She wasn't overturned for this decision last time, so why would she change it this time? That's her mindset. Specifically, Ms. Reed proposes that the court use the verdict slip attached as Exhibit A. We're going to look at that together, which presents formatting changes, not substantive changes, to the court's verdict slip. That the jury has started deliberation does not preclude the amendment, affirming verdict slip revision during jury deliberations. I don't think there's anybody on the jury that would be like, oh, wow, this huge change that we have in the verdict slip is going to make me change the way I would vote. I don't think that's going to happen. I don't. Indeed, the court amended the jury verdict slip in Ms. Reed's first trial while the jury was deliberating. A verdict slip is a tool designed to aid the jury, a recognized means of reducing errors in the rendering and announcing of verdicts. It is well established that verdict slips are of no binding legal significance. A verdict slip as a matter of law requires a public announcement in open court. No verdict exists if none was announced. It's like the defense is now citing case law that was bad for them before. Because verdict slips are tools to aid the jury, their primary goal, in addition to ensuring a defendant's rights, should be clarity for the jury in both understanding its charge and reporting its verdict. This case crucially found that the verdict slip only served to confuse the jury. In another case, the current jury verdict slip has the real potential to confuse the jury and cause errors, particularly with respect to count 2, manslaughter while operating a motor vehicle under the influence of liquor and its lesser included charges. The form does not explain the process the jury should follow while completing it, although the court instructed the jury that the form should be completed from top down. From the form itself does not provide instructions to stop after the jury has selected a given box. And that's why I thought it was important for us to go back and listen to exactly how Judge Cannoni explained this to them. I'm going to read some comments here because people are having some fun. PETA, thank you for giving me and the chat, a better understanding of our legal system. Thank you, Leslie. Chris K. Peter, I was disappointed to find out that you are only a civil lawyer. Is there anything else you haven't told us? Is that, in fact, your real hair? So Chris is joking, probably based on some of the stuff that, yes, this is my real hair, by the way. Basically on some of the stuff that's going on in Twitter. It's just really hilarious. People are posting my website as if I didn't write the stuff on my website. And as if I don't say every single time I'm a personal injury and wrongful death lawyer. That's what I do. 99% of my practice is that. 1% is criminal law. They act like, oh, why should he ever comment on criminal cases, even though I've prosecuted criminal cases, defended criminal cases in state and federal court, tried many criminal cases, grew up working in my dad's firm. Well, all he did was criminal cases, was a law clerk, legal assistant, and did paralegal work on all sorts of criminal cases. But yes, Chris was joking. Because it's really funny, the people that are on the internet and how they think they're taking shots. It's funny. How'd you and Papa Tragos hit him on Friday? Just checked and didn't see a score posted on gin. Oh, that's a good point. I should post my score on gin. Here's the problem. My dad always takes the cart at the end to go like into the clubhouse for us to eat. And I walk my clubs to my car to drop them off before we eat. And then we always lose the scorecard. I think I shot right around 81, something like that. My dad hit him pretty good. It was a little higher score, but he hit him pretty good. No complaints there. I pray for Karen that they make an amazing movie out of this and give her half the proceeds so she can live a beautiful rest of her life. I think Chris had to come. Yeah, here we go. Peter saved me. My sarcasm fell flat. For the record, if I needed an attorney for PI or criminal, Peter is my first call. Thank you, Chris. Yeah, he told me he was going to mess with me on this. So all good fun, all good fun. I welcome it. I welcome the sarcasm, especially from people like Chris, who are always here, who are awesome, really uplifting in the comments and the DMs. I love you all that reach out. I appreciate you all. I can't obviously respond to every single one the same way, but they are seen. I love it. I appreciate you guys. Everybody that's here to hang out, talk about these cases, and that comes and chooses to do it here. There's tons of places you can do it. I appreciate it. Kathy said, Peter, I can't stand reading the comments about you on X. It is what it is, right? That's what Twitter has just kind of become. I still am going to post on there, still going to try to talk about this stuff. Hopefully people can learn from it. I can learn from a lot of your comments. The mute button is a beautiful thing. Let people scream off into the abyss. But it doesn't matter, right? In the grand scheme of things, I know who I am. I know why I do what I do, and I love it. And I appreciate all of you guys that come out and are very loud in support. You guys are the best. It does not go unnoticed. All right, let's get back to this motion that Ashley, speaking of shout outs, sent to me, and I appreciate it. She sends me all that stuff. The form does not explain the process the jury should follow while completing it, although in court instructed from, okay. We already read that. Moreover, the form presents the jury with only a single not guilty option applicable to count 2 in its entirety, juxtaposed with 4 guilty options, 1 for each charge. This imbalanced presentation visually favors the guilty options and risks creating bias towards a guilty verdict in degradation of Ms. Reed's rights, in addition to creating the risks of confusion and errors. In furtherance of the salutatory goals of maximizing clarity and avoiding error, Ms. Reed proposes the verdict slip attached as Exhibit A. The proposed verdict slip has several benefits. First, the form includes clear step-by-step instructions explaining to the jury whether they should stop or continue based on their findings for a given charge. Although Massachusetts law does not dictate how or in what order a jury must deliberate, the jury must return a verdict of the highest crime that has been proven beyond a reasonable doubt. The proposed verdict slip's clear instructions aid the jury in complying with that mandate. Additionally, the proposed verdict slip makes clear the jury's choice between guilty or not guilty for each separate charge. Why wouldn't we want that? Instead of presenting only a single not guilty option encompassing each and every charge that is part of count 2. This balanced presentation gives equal weight to both possible outcomes for each charge and avoids any implicit bias towards a guilty verdict, providing the jury with a clear choice between guilty or not guilty for each charge while following step-by-step instructions also minimizes the risk of confusion to the jury. It is beyond cavil that the proposed verdict slip is clearer than the current jury verdict slip. Ms. Reed respectfully requests this court now substitute the attached verdict slip for the court's existing verdict slip in use. Okay, before we get to the verdict slip, I'm going to answer a few more questions. Some guy at work in Boston, whole office is waiting for the verdict. Gorgeous day here in Massachusetts. Surprised the jurors don't want to get outside. Well, they're taking their job very seriously, as they should. And I think that's something we should be able to respect and appreciate about them, and something that should be celebrated. Judge Canoni started the jury instructions with, if there's a difference between what I say and what's written, go off what I say. Is that standard? Usually it is, because that's what's going to be on the record. That's what the lawyers are listening to. It doesn't mean you don't want to correct what's written and sent back there with them. I listened to her instructions again. I heard this as well. If the jury is confused on how to mark the verdict slip to achieve a specific outcome, can't they just ask the judge? So they can. They can say, hey, we're confused. What are we supposed to do with this? Judge, we're really confused on count 2. We want to check not guilty on 1, but we don't know how to move on. She also says, kind of at the bottom of the page, you're supposed to be done and sign it. We'll listen to that as well. That I think could be confusing. I saw no issue with the slips, but agree there's no reason not to adjust. And that's kind of the point. Why not pick the best option? Because I would agree, I don't think she's going to get overturned on this decision. In my opinion, any issue might be definition of lesser includeds, not the form. If a juror, a timeline with objective data, cell phone text, voicemails, videos, or car data, I lean count 2. Chloe, I bid him. Peter, if the jury is hung again, who do you think will try her a third time? I have no earthly idea. Peter, do you think the makeup of the jury leaning more female will help or hurt Karen or have no effect? Love from the Panhandle. I would assume female would help. Generally, you want to identify with the people on the jury, and a female in a relationship where maybe John O'Keefe, if Karen's saying like he wasn't very nice to her, maybe females can relate more. I don't know. I think the age of the jury might be more important than the sex of the jury on this one, but I don't know. Mary Claire, I hear what you are saying, but biased Bev did actually make a change, albeit minor, in the first trial. Bev is doing everything she can to ensure a win for the prosecution. She is corrupt. I had to get this off my chest. Assuming it's a hung jury and they go for a third trial, can't the Commonwealth be held accountable for basically wasting taxpayer money and using this trial as a vendetta rather than a search for justice? So while you and I might see a hung jury as a loss for the Commonwealth, that still means people think she's guilty. They're still fighting for justice for a fallen police officer and for his family. So it's tough. Appreciate your coverage, Peter. Glad you don't let the haters change the way you present your opinions. You and EDB get me through my work shifts. Ha ha. Not guilty. And I have a feeling Emily D. Baker feels the same way. John, how about JJ Spawn's putt? So I bet him after day one, hit, and then sprinkled a little bit on him to win. I did not expect him to win. He pulled it off. What a tough tournament that was. Cool that it happened over dinner time on Dad's Day. I agree. That was awesome. Azam, hit the like button and subscribe if you haven't already. Let's get Peter to 510 on this live. That would be awesome. Everybody hit that subscribe button. Okay, I am now going to pull up the defense proposed verdict slip here so we can look through it. All right, so this is Exhibit A to that motion, and we're going to start with count one. It is a very simple box that says, in the above title case, we, the jury, say the defendant is, the type is the crime charged, the crime is M in the second degree. Then you have two boxes, not guilty or guilty. And this is the unanimous decision of all 12 members. 4-person signs the bottom and dates it. Very simple, no issue, not a big difference from the one that the jury has, which we're going to take a look at that as well to compare and contrast here in a second. Also, it's past 4:20. So let me check the court feed and see if they're back in court. They are not, at least from what I'm seeing on Court TV's stream. You guys can let me know if they are. My guess is they're just going to send the jury home for the day, but we will watch it together if it is. Wait, Peter, aren't you going to go to the live? So there's nothing. They're not showing court right now. If they show court, we will go there. Don't worry. But I am 99% sure they are just going to send them home for the day. We will watch it together if it is streamed. Okay, they just came back. Everybody's saying, is that on Court TV? All right, let me pop that in. All right. So this is live. Court's in session. Okay, law and crime. All right, let me go to law and crime. All right, we got it. We're up. All right, here is the Law and Crimes feed, and we are back in the courtroom here.
We're back in session. You may be seated.
All right, jurors, we appreciate how hard you've worked today. It's been a long day. I'm going to send you home. So I do have to give you those cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Be careful with your social media use. And I think what's a good idea to do is when you leave here, just leave the case here. Literally, figuratively, just clear your heads. Beautiful day, get some fresh air, and we'll see you tomorrow. Okay? Thank you.
All rise for the court, please. Jurors, follow me.
Somebody said, what happens right after this watch? So I'll take the bait. We'll watch for a little bit longer.
All right.
Cut the quorum, please proceed.
So we'll see everybody tomorrow morning, okay?
Thank you.
All right, thank you.
All right.
Okay. So that's it. I will keep this one up in the background just in case, of course. You guys can let me know. Lori, thanks for gifting 5 Lori, memberships. All right. So we are jumping back into the verdict slip here. And we read count 1. That was kind of the simple one. Now we are going to get to count 2. Count 2 is and I've got, so if somebody said that Vinny is trying to talk to Karen Reed, if he does, let me know. We can watch that together too. When she walks out. Okay, so count 2. Here we go. Crime charged. Manslaughter while operating a motor vehicle under the influence of liquor. If guilty, check one or both. Manslaughter while operating a motor vehicle under the influence of liquor. Manslaughter while operating a motor vehicle with a blood alcohol level of 0.08. The reason these two are here is which way did they prove that she was driving drunk, basically? Was she under the influence or was she above a 0.08? Then they have a not guilty box and a guilty box. If you find the defendant of the crime above, guilty of the crime above, stop. It's over. If not guilty, continue below. And this to me goes top down, like Judge Cannoni tells the jurors to go in the jury instructions, which we're going to listen to here in a second. Involuntary manslaughter, guilty, not guilty. Motor vehicle homicide, felony OUI, and negligence, guilty or not guilty, guilty. Same thing. If you find guilty of the crime above, stop. If not, continue. If not guilty, continue. So we know they only continue if it's not guilty. Then we go to operating under the influence. Same thing. Not guilty and guilty. Very simple. A chart. I love a good chart. Then count 3, simple. Leaving the scene of the accident resulting in death. Not guilty or guilty. So the real part where this comes into play is if they found, let's say, not guilty on this and they're hung on involuntary manslaughter. Well, next time they cannot, if they, obviously not guilty here, and they get to here and they're hung and they're not guilty here, right? They cannot try her again for leaving the scene of the accident resulting in death. They cannot try her again for second degree, and they cannot try her again for manslaughter while operating a motor vehicle under the influence of alcohol. That's really where it comes down to. If there's a hung jury. If it's not guilty across the board, this isn't going to be an issue. If it's guilty of count 1, this is not going to be an issue. If it's guilty if it's guilty of any of them, it's not going to be a major issue, except for the fact that they may have said, we didn't see a not guilty option for the lesser included, which let's now take a look and just kind of compare and contrast the verdict form they actually have. So here's count 1, not guilty, guilty. Count 2, not guilty of the offense or any lesser included. Some would say objection, compound question, right? Objection, compound question. But then you have guilty of the offense as charged, manslaughter while operating a motor vehicle, guilty of the lesser included, involuntary manslaughter, guilty of lesser included, motor vehicle homicide, guilty of the lesser included offense, operating under the influence. Much more confusing. Because sometimes it could feel like if you think it's not guilty, then you still feel like this looks like every other one, right? 1 and 2, 1 and 2, 1 and 2. So if I think she's not guilty of this manslaughter, am I then going to go down and look at these 3? What do I do with these 3? Now, it very clearly says, or any lesser included, which I understand. I just don't know why we wouldn't want it to be clearer. I think that this is going to pass muster on appeal. I do not think they're going to win for this appellate issue. And it's kind of cheating because we know they already didn't win on this, but not guilty of the offense charge or any lesser included is probably good enough, but it's not the best answer. And in law school, with so many of the tests we take and exams and even the LSAT, it's not always the right answer because there can be multiple right answers. You're supposed to pick the best answer. And so to me, I agree that the defense's option is the best answer, but I do not think this is a situation where it's going to be something that's overturned on appeal, at least That's the way I see it personally. Okay. So now let's get to, we kind of already know the answer to this, but I thought it would be interesting to, oh shoot, did I just lose it? Okay, here it is. I am going to bring up now this little interview that was done with Karen Reed earlier today regarding this motion that was filed by the defense. Let's hear what she had to say about it.
There was no preparation this weekend. What did you do for the weekend now that you don't have to prepare anymore?
We wrote a motion to reconsider the verdict slip that was just denied without a hearing.
You want more boxes added to that verdict
Yes.
slip, the lesser included.
Yes,
Can you explain why that's important to you?
I think what happened.
So she said it was denied without hearing, meaning Judge Cannone just immediately denied it. She had already considered something different from Cannone or from Yannetti before and denied it. No surprise there.
I think what happened last year with the same verdict form explains that the jurors themselves were confusing, and it said as much. So we just wanted to avoid that again. And apparently, the board is not concerned. So we'll just move forward and we don't.
What am I walking on?
Overall feelings heading into today, Karen?
I feel well. I feel strong, and the jury will do the right thing.
What are you going to do now?
Shows them.
What are you going to do right now?
Eat something.
Do you feel more confident with 7 women on the jury?
I don't even know what the breakdown is. Is that what it is?
7 women, 5 men.
Oh, stop. Somebody lost their shoe.
You chose not to play extended clips. Those media clips, you had said you might play more to put them in context. Can you give us some insight into that decision?
I can't. Sorry. Little walk through.
You guys are all roped up here.
And so that was
All right. So that's it there. Denied without hearing. Obviously, they're not pumped about that. I'm going to answer a few more questions, and then we're going to listen to some more of exactly how Judge Cannone, and if you guys want to, we can refer back to the verdict slips, because this is kind of what the jury has to do, right? They've got to read what is the offense charged, right? Let's read the definitions. Let's hear it explained to us. We know all about the second degree charge. So we're going to first we're going to pick up with Judge Cannone discussing just the verdict slip generally that we listened to before about just one page. This is a real quick 1 minute. Then we're going to get into how she explains that second degree charge, because I think that has a lot to do with the verdict slip and how it's written out for count 2. I think I may have said second degree charge. I meant the second count. So first, let's take a listen to this.
On this verdict slip as well, and I'll explain those to you as well. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and...
Shoot, sorry, I messed that up. Sorry. This is the 1 minute. The 1 minute clip is what I wanted to play first, and then we'll get to that where we just were. Here we go.
Mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Keep an open mind until then. For each indictment, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of that specific charge. Your decision as to each charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive 1 verdict slip for each indictment. When all 12 jurors agree on the verdict for a particular indictment, the foreperson should check off that verdict and then sign and date the slip in ink. For each charge, if you all agree that the Commonwealth has proved every element of the charge beyond a reasonable doubt, then you should find Ms. Reed guilty of that charge. On the other hand, if you all agree that the Commonwealth did not prove one or more elements of a particular charge beyond a reasonable doubt, then your verdict must be not guilty on that charge. You'll remember that we took a view.
So that was as simple as she discussed it, explained it. Will the jury have issues or questions about it? We'll see. We'll find out. But at this point, I think that she explained it to go sheet by sheet, basically. I do think that creates an issue potentially with a hung jury on a lesser included for count 2. Rich Ryan, I think it's simple. If you check not guilty at the top, you don't need to look at any of the other lesser charges. It clearly states not guilty of lesser included. I tend to agree. I think it makes sense with the words. I think there's a lot of pressure on the jurors. And it's not like they're only looking at this one piece of paper, which is going to become apparent when we get to Judge Cannone reading through all of the lesser included, the definitions of everything, what they need to consider, and how they get there, right? That's what we have to combine with it. For some reason, Peter, I feel like you know your worth. I told someone today that I got my Facebook law degree at Lawyer You Know University. I've been hearing a lot of that, and I love it. I love it. Mary Smith, is a third trial typical, or would two hung juries mean a judge would dismiss? I don't mean Judge Cannone. I mean any other judge. It doesn't mean typically that it would be dismissed. It really depends on the prosecutor. And everything the prosecutor's done throughout this entire process has led me to believe that they would try her again. Big fan of justice. Thanks, Peter, for explaining the new developments. I live in Los Angeles, and it's scary how the government has the right to do what it's doing. Being here with everyone is a reprieve for me. If Karen Reed is found guilty, I will lose faith in our justice system. There will be appeals. There were issues. So I will say it's not over even if she's convicted. I've had cases like that where it felt horrible and the client was like, oh man, my life is over. We're like, hold on. We have real appellate issues, and sometimes you win appeals. Sue Lima, if it's hung again and they decide to prosecute her a third time, would the taxpayers have a say in the cost, specifically after the Blues Clues recreation? They can get loud about it, right? They can get loud about it. But they're not the ones making the actual decision, right? You vote people in place to make these decisions. Sometimes it really can be an issue. Coffee Cake, when do we start to panic? Okay, yes, let me get the, so this was a little before Kelsey sent me the votes, but it's 61% of people think Tuesday, 29% think Wednesday, 5% think next week. 5% thought today, but that was before we found out the jury already went home today. So the majority of people think Tuesday. That's what I've kind of thought. Before lunch, Tuesday was always my thought. I think if it was going to be, so before we get to Cannone reading more of these jury instructions, let me just tell you my thinking, okay? If they were going to convict on second degree, I would think that would be done by now. I could be completely wrong about that, okay? I'm using my experience of how these things usually work. If they were going to be guilty there, then I think it'd be done. If they took a look at the third count and they're like, no way she knew, I think it's possible they cross that one out. Okay. I think it's possible. Maybe they're waiting to get to count 3 until they work through count 2. That's very possible. But the longer it takes, the more that is an indication that they're working through count 2. Now, whether it means guilty or not guilty, I don't know. I think it's pretty clear at this point. It's not a slam dunk either way that they are discussing. And we've heard in other cases how most cases, I shouldn't say most cases probably walk in and everybody's like 12-0 guilty. That's probably what happens in most jury rooms. But in ones like this that are very difficult, it's not uncommon for it to be 10-2, 9-3, 11-1 to start. And you can work your way to convincing the last 2 or 3 jurors to go with the majority. And sometimes that absolutely takes time. And sometimes it gets like YNW Melly, where one is dug in and never going to change their mind for whatever reason, and we may never know, and that can last days. I would think the closer it gets to Wednesday, the more decision-making Judge Cannone and the lawyers are going to have to make. What do they want to do? Do they want to push this jury? Do they want to give some kind of charge, telling them, let's go, come to this decision? I would not want them to as a lawyer if they're not telling me they're stuck. If they're telling me they're stuck, sure, let's give them a charge. If they're not telling me they're stuck and they want to keep going Tuesday, Wednesday, and come back next week on Monday, so be it. This is part of the process. Let them work through it. If I'm Jackson, I'm thinking I gave these people the ammunition to go back there and fight for a not guilty verdict. Let them fight. If I'm Hank Brennan, I said there are people back there that believe she took the life of this officer who was a good man. Let them fight. So either lawyer, if they believe in the arguments they made, they should want these jurors to stay back there and fight. Fight for what they believe to be the proper verdict. I saw a comment about my dad. I'm sure there's more coming in. As is most podcasts, there's people talking about, me and my dad's interactions, how I interrupt him, how I argue with him, how he argues with me, and all this stuff. And it always makes me laugh. And my dad reads them and laughs too. He'll send them to me saying, ha, 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 I created a monster is basically what he thinks. Because in my house, You're not given anything. You got to fight for everything. We negotiated bedtimes, what we could have for dessert. My kids, same thing. You negotiate everything, right? Everything you have. When I got my first job at our firm, I was clerking at a firm in Tallahassee that did criminal defense, medical malpractice, and personal injury, and I loved it. That's my first experience with personal injury because I had only ever worked at my dad's firm doing criminal defense, and I loved it. Really good dudes. Brooks and LaBeouf in Tallahassee, if anybody wants to look them up. Great firm. And they offered me a job. And I was like, Dad, I didn't even want to clerk there, but one of the partners there, Matt Foster, was one of our mock trial coaches. He's like, I want you to come work for me. I want you to come work for me. Come learn from me. He's a great trial lawyer. So I did. And I'm like, Dad, they offered me a job. I might want to stay in Tallahassee. I love Tallahassee. My dad's like, no, I want you to come work for me. I was like, well, here's what they offered. It's like, you can offer me that? And he said, I'm not going to offer you that. I'm going to offer you this. He was always going to offer me like whatever government workers' salaries were, and like the public defender, state attorney. And so we negotiated, and he came up from what he was going to offer me, but he did not match what the firm's offer was in Tallahassee because he just refused to do that. And in case you didn't know, Tallahassee has a lower cost of living than Tampa, Florida, but my dad would not match their offer. That's just how life is. You got to fight for everything you get in our house. And that's just how we talk to each other. I love my dad. I think he's the best lawyer on the planet. He's the best lawyer I know, best lawyer I've ever met. I've met a lot of really good lawyers, talked to a lot of really good lawyers. I have not been as intimately involved in how lawyers break down and try cases like I have with my dad. So that might, skew and make me biased, but that is how somebody said, wow, we have a peaceful house. I love it, man. We fight for peace. We're a peacemaker. There's different kinds of peacemakers. There's peacemakers that do it with a smooth, a soft, soothing voice. And there are peacemakers that make peace with the way that they battle it out. And we're that kind of peacemaker, I like to think, because we are peacemakers on all those charts where you do the tests. Okay. Sorry for that story time. Let me answer some more questions. The current slip seems to allow only a hung jury for the whole charge. What if they are just hung on OUI, for example, jury pool? There are ways that the defense can try to do that, but it might be difficult and Judge Cannone might not allow it. Bobby, Peter, thoughts on the Raffy Devers trade? Devers don't say Devers. I had just seen, I follow all these Boston people. I don't know why, or they're all over my Twitter feed, like even some famous Boston people. And they were all excited about the Red Sox. And then boom, you trade. I think he's their best player. I don't even know. I think a longer deliberation is probably a good thing for Karen Reed. I think it means good for the top charges, but I think they're battling on some of the lesser. Does Bev decide when the jury goes home, or do they decide? It's usually a combination. Definitely the jury can decide, like, we're done for the day, we want to go home. After this case, do you think people who are assigned anti-Bev in their cases will ask for a different judge? Is that allowed? I mean, we just saw her give a not guilty verdict on a bench trial for a criminal case, and she's a former public defender. So I don't know. I don't know if it's just something about this case or what. Why is the defense submitting another proposed jury form when the judge denied their request to have it changed? I don't think that they gave a specific verdict slip the first time. I think they were kind of making an argument, trying to get the verdict slip done the way that they wanted to, but I'm not sure they ever actually concocted what they wanted it to look like, and that's what they were able to do here. Everyone saying hung needs to calm down. It's day one. Yes, there are multi-day deliberations. I will say this one feels tough, and I think we're all a little skewed from the last one, but we'll see. Hi, Peter. I'm 64 and made my first hole-in-one, 110 yards. Woohoo. I don't care if it's from 60 yards, Glenda. That's amazing. I love it. I love it. Hopefully many, many more. But how would you indicate not guilty on 1 through 4 and guilty on 5? Well, Bobby, how you would do it is you would just check guilty on 5. And that would assume not guilty on all of the others. That's legitimately legally what it would mean. Does the jury understand that? I don't know. All jurors are equal. It should be third grade reading level. As simple as possible. And it's not an offense to the jury. It's just, we want to get it right. So if they find her not guilty on count 2, they must not consider any lesser included. No, they must consider the lesser included if they find her not guilty on the manslaughter by OUI. Amy, why didn't AJ argue that partygoers took JOK's phone at 12:32 and put it by the flagpole? Perfectly explains the phone held data, temperature data. He has to have evidence of that, right? What evidence does he have of that? Is the jury going to know what lesser included means? Thank you. So, this is a good transition. It's a great segue. I love when a comment is a good segue. Let's listen to Judge Cannone explain to the jury count 2.
Of liquor. And there are lesser included offense of not. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt,
here we go.
You must return a verdict of not guilty. Now, the second indictment is the indictment charging manslaughter while operating a motor vehicle under the influence of liquor. And there are lesser included offenses on this verdict slip as well, and I'll explain those to you as well. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. To prove the first element, the Commonwealth must prove beyond a
So she's going to dig into that even more, okay? That's what she's explaining for the top count on count 2. The verdict slip only says manslaughter while operating a motor vehicle under the influence of liquor, manslaughter while operating, so then guilty of the offense as charged, manslaughter while operating a motor vehicle under the influence of liquor, check one or both of the following: manslaughter while operating a motor vehicle under the influence of liquor and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater. That's all it says on the verdict slip. So they need to read or remember how she is explaining everything she's explaining, because it doesn't give all these definitions and explanations on the verdict slip. So that's why I kind of want to listen to both and marry them together.
reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the things, the well-known things that drivers do as they travel on a street or highway, and also when doing any act which directly tends to set the vehicle in motion. A person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which alone or in sequence will set the vehicle in motion. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way. This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing, and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, and whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after.
So here are the two check boxes or lines under the highest count on charge 2. Okay. So we know, we just looked at that together. You can rewind if you want to see it. But actually, let me just show it to you. I've got it right here. So just while we're doing this, we can take our time. No reason to rush. We're all here just waiting for a verdict, and they've gone home for the day. So these are these two that she's explaining now. Why are these here? Why are they checking these? She's explained to them. They're in the written instructions they can refer to later as well. So this is all it says. For everything she just read, they have one line here explaining that. And now she's going to explain what these mean. This is all just for the top charge, and then she's going to get into the lesser included, so you can hear exactly how Judge Cannoni explains this to the jury. And do you think there's going to be any issues understanding what they should do?
To consuming alcohol, as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely. By decreasing.
So some people have heard in other jurisdictions that their normal faculties are impaired, right? It's usually normal faculties impaired or above a 0.08. You can be perfectly fine. Like you can just be a good drunk, right? You can be at 0.12 and still be perfectly fine. Like this, right? I got the hands of a surgeon. Mine don't shake. You're still guilty of a DUI if you blow above a 0.08 or if they prove blood alcohol level, whatever it may be, above a 0.08. Or you can be at 0.06 and slurring your speech and falling over, whatever. I've never been drunk, so I don't know what I would sound like drunk. But that can also make you guilty of an OUI or these elements of OUI with the manslaughter charges. So it's either or. You don't have to be above a 0.08 and normal faculties impaired.
Increasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that the defendant's ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed alcohol. However, no matter what the reading is, the blood test is not sufficient by itself to prove that the defendant was under the influence of alcohol. Under the second theory, the Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was 0.08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly. You may also consider any other evidence pertaining to the test or the test results. The fourth element the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently, that is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness.
And that's the difference between some of these charges, right? Recklessness, wantonly, recklessly, knowing it was dangerous, not just negligent. That's the big difference in, some of these lesser included to focus on. But the jury's got to, they should put up the pages next to each other basically to compare them.
The defendant was reckless if she knew or should have known that such actions would pose a grave danger of death or serious injury to others, but chose, nevertheless, to run the risk and go ahead. Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent, even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Here, the defendant must have intended her acts in the sense that they were not accidental. But it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in that category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation: the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well the defendant could see and control her vehicle. The condition of the defendant's vehicle, what kind of road it was and who else was on the road, what the time of day, the weather, and the condition of the road were, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant caused the death.
And this is the big one. Like, it doesn't necessarily have to be a strike, but causing the death with her actions of being drunk and driving, right? Because some people say if she backed up, made him dodge the car, slip, fell, hit his head, whatever it may be. But was it reckless, not just negligent? These are kind of the questions, but the causation is a really big issue for me and probably a lot of people out there with when you go to the scientific and the medical testimony. That's why the Commonwealth's theory is so important. They're saying hit, shattered light, scratched his arm, causing him to fall backwards and hit his head. So that's why it's so important in this description. And a lot of you are pointing out how long and laborious and boring these instructions are. And hopefully the juror's not zoning out. But a lot of people are also asking what's taking so long. No juror in a very serious case like this should just rely on their memory of what Judge Cannoni read, 2 days ago or 3 days ago now from this, 10-minute spot. They should go back, read for themselves, dig in, and that can take a lot of time. You can see, I hope what they're doing is saying, okay, let's slow down. There's a lot of words here. Do we know what reckless means? Do we know what driving under the influence means? Do we know what above a 0.08? Did they prove this? Okay, yes, they proved this. They proved it. Okay, they didn't. Okay, we don't agree if they prove this or not, because they should all vote really on each element as they go down. you can start to understand how that can take a lot of time. A lot of time. Unless it's obvious they're like, she did it, guilty, or no shot, she did it, not guilty, which I don't think either of those are happening in this jury room right now. I think if it was an obvious down the line, guilty or not guilty, this thing would be over. That doesn't mean it won't end up being guilty or not guilty. But I don't think it's, a lot of people online are like, oh, this is so easy, so obvious, slam dunk. But there are a lot of things going on both sides of this. Abigail Bargazzi. Hey, Peter, thank you for all you do. What would be Aunt Bev's con or pro be to changing her slip to help clear it up? What's the problem? So the pro would be to simplify it. The con is it's different. Will everybody else ask to do this? Will doing something different actually create an issue? If you do something that other people don't do, and up on appeal, if you're the one changing things, you don't want to be a trailblazer in the law usually as a judge. So from my perspective, she probably just wants to stick with status quo, which is how most judges are, if you believe it or not. Peter, coming in late, but isn't this kind of a good sign that they haven't had any questions for BC yet? Some jurors, sometimes I think it's a bad sign when there are no questions because they don't realize they can ask questions. And then they start doing things wrong and they start just trying to guess at what they can do. I like questions personally. Verdict slip is confusing to me. If I was a juror, I would have anxiety. If another hung jury would higher courts remove Bev because it looks bad, not necessarily for that reason. Hi from Sweden. What if you disagree on 5, but find not guilty on 2 through 4? No option to choose that. So does it end on hung for all counts? It shouldn't. It should really end for a hung just on count 2. Although she said top down and do each sheet individually. So it's also possible if they hang on count 2, they wouldn't even go forward to count 3. And then they'd have to determine what they do there. Do they send them back or what? Boston accent advice for you, Peter. A lot of people have tried this. I just am not good at it. Say pita, as in bread. Slightly shift the T to a D. Pita. Pita. Could the judge change her mind regarding verdict form before giving the Allen charge if they come back hung? The DA is up for re-election with others running. I don't know if I would love that. I don't know if I'd love that. If they're hung and then you give that. Allison, are there any powers that can limit the amount of time deliberating, or it could go for an infinite amount of time? Thanks for all your coverage. If this case, a pediatric critical care RN, confident she's a lawyer now too. So not necessarily will they step in and limit it, but they can give the Allen charge. Like if it's next Monday and they still haven't come back with a single question, then maybe, but usually if they are deliberating and they're working, usually you're not going to step in. Zin, can you explain how they was able to recharge Karen with the 2 charges that the jury found her not guilty of? How is that not double jeopardy? They didn't fill out the verdict form. It wasn't an official verdict. The appellate courts felt the same way. Judge Cannoni felt the same way. And because it was not an official not guilty verdict, they found it not to be double jeopardy. I love watching the dynamic between you and your dad. I love it too. And I think it'd be really boring if I just sat there and didn't say anything and let him talk. Peter, do story time with Big George. He can regal us with his trial experiences. So I want to do a Q&A. I want to do a just bring my dad on Q&A, no content that we're actually going to be presenting because I know it's going to go long with him answering a lot of those questions as it is. So I do want to try to do that this week. Cassie, I live about 15 minutes from the DA's office and plan on protesting there if they do another trial. I don't want to pay for this again or see it happen again. If people are hating, I assume you mean me. It means you're doing something right. I must be doing something big right. Keep doing you. If they got a problem with Peter, they can come talk to me about it. See Anthony. All right. See Anthony. Kelly, didn't Rittenhouse come back? I think 3 days. I can't remember, but I do think it was multiple days. The time of what? If she didn't hit him, why is she being charged for OUI? Wouldn't all the people be guilty of that too? Theoretically, if they can prove it, I guess so. If it's not guilty and hung on only OUI, is a mistrial on our charges per Massachusetts attorney, weird mass rule. On the second charge, you mean, I would assume. Mistrial on counts 1 and 3 as well? I could see it as a mistrial on all 3. I don't think Massachusetts is the only one that does that. And that could also be an indication as to why the verdict form is the way it is. Because you don't want to create this appellate issue where is it not guilty on those higher charges? If Massachusetts has a rule, I got to look that up. How can they get her on under the influence of alcohol charge because her blood draw was due to a psych hold, not a traffic infraction, and they can't prove she didn't go home and drink? So the blood draw, in most cases, you are allowed to use a medical blood draw to prove DUI or OUI. And if the jury felt like there was no evidence she went home and drank and that she was above the limit, based on the testimony and evidence at the time, how many drinks she had, the video footage from the bars, things like that. Her BAC was drawn at 0900. The next morning, she rode with Jen to find them. So the last time Karen drove was the night before. They had to prove she didn't drink. After reaching J.O.'s house, they didn't, right? It's up to the jury if they proved it or not. To me, I think it's very weak as far as like a DUI charge goes, but they didn't take a lot of the time battling that. So I think the jury's probably going to think she was drunk driving. It's just a feeling I have based on how jurors usually view that. And based on what the last jury said, because the defense did not focus on fighting it because they had much bigger fires to put out. The second indictment should be an automatic not guilty. 2 medical examiners, including the Commonwealth witnesses and the experts who actually did the proper testing, all said he was not hit by a car. By the way, if Massachusetts really does have that rule, maybe a big mistake for the defense. It sounded like the defense was pushing for the OUI lesser included. So that's happened to me before, where we've split the baby on a difficult, we tried a premises liability trip and fall case that ended in surgery, huge damages. But we split it and we tried liability first because we knew if we won, they would pay on it because the damages were huge. But they felt like it was our client's fault. So we tried the case and we were like, okay, whatever percentage we get, fine. If we get 75%, fine, we'll reduce the verdict by 25%, whatever, or the money. Well, it ended up a hung jury. And we were like, oh man, it turned out everybody on the jury was 100% in favor of our client except for one who thought it was like 75% the defendant's fault, 25% our client. So it was like way better than we thought. But the hung jury ended up being bad for us. We thought it might be good for us. The OUI, they thought it might be good for them if she's just convicted of that. But I heard in Massachusetts, or I read, you can get up to 2.5 years in prison for that, which is crazy. But if they end up hanging on the OUI, that means they can retrial for the second degree again, which is the scariest charge for the defense, I would think. But I don't know. I got to look that up. Am I correct that even if the jury thinks Karen Reed was legally drunk, if they find that the evidence does not show that there was a collision, they should find not guilty on all lesser included offenses? So no, I think they could still find her guilty of the OUI, even if there was no collision. The OUI is just operating a motor vehicle under the influence of liquor or operating a motor vehicle with a blood alcohol level of 0.08%. It's just operating under the influence. It's not resulting in death or serious bodily injury or anything like that. But we are going to hear Judge Cannoni explain that. Let's take a listen to her explain these lesser included now.
If her actions directly and substantially set in motion the entire chain of events that produce the death. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, and without which death would not have occurred. If the Commonwealth has proven all 5 elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with that lesser included offense. The Commonwealth may prove the lesser included offense of involuntary manslaughter, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence. So I'm going to define involuntary manslaughter for you. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, the defendant intended the conduct that caused John O'Keefe's death. And third, the defendant's conduct was wanton or reckless. I will now discuss each element in detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that
Again, we're still above negligence.
substantial harm will result to another. It is conduct involving grave risk of harm to another that a person undertakes with indifference or disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of great danger. Even if
So reasonable person standards on trying to determine what she understood when she made the decision she made, and it has to be more than negligence, and that pesky causation element is still there.
the defendant herself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined that term. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite knowledge even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI, and negligence. As a matter of law, the indictment that is before you that charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor also charges her with the lesser included offense. With that lesser included offense, the Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while
So now we're going down another tick, right? So we had manslaughter while operating a motor vehicle under the influence of liquor, involuntary manslaughter. Now we are at motor vehicle homicide. Okay, so we're going one by one. By the way, quick research. We're going to do more talking about what the potential sentences are. But count one, the M2 charge, obviously up to life. Okay, that would be the most serious. OUI manslaughter, 5 to 20 years. Involuntary manslaughter, you can still get up to 20 years. The vehicular homicide while drunk, 30 days to 2.5 years, I believe is what I saw. And then the OUI is up to 2.5 years. So you notice the difference kind of on the minimum and maximum side of each one, but all of these are very serious. Even the OUI, if she gets sentenced to 2.5 years, like that is life changing, obviously. Kelsey, they want to do a poll on just the OUI charge. So do OUI charge, guilty, not guilty, or hung jury?
operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. On the verdict slip, that just means you start from the top and you work your way down. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth...
That would make me think if you're hung on count 2, you never get to count 3. The way that she's explaining it.
Must prove the following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as previously instructed a few moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element, so I'll focus on that. To prove the 4th element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that...
That's the difference, right? We're working our way down. What the standard is, what did she know, what was her intent, and, you know, which ones are wanton, reckless, and then negligence. That's why, if you're wondering, that's why the charge is so much, or the potential sentence is so much less. So instead of a minimum of 5 years, maximum of 20, or up to 20 years like involuntary manslaughter, when you get the vehicle homicide by OUI, 30 days to 2.5 years because it's an accident. There was nothing, the intentional element changes. It wasn't reckless. It wasn't like you knew something bad was going to happen and chose to do it anyway. So that's why the potential sentence goes down so much. But it feels really kind of wild that vehicular homicide while you're drunk and drunk driving with no homicide can have the same potential sentence. It's kind of wild.
might have endangered the lives or safety of other people. A person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by not doing something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that she could have avoided by driving more carefully.
And again, that's negligence. That's what she's discussing here. Also, we're at the hour mark. We're almost done. We'll probably be done here pretty soon, but hit that like button. If you guys haven't already, hit the like button. We're still going to be doing coverage all the way through, verdict watch, discussing the verdict. Maybe I'll bring my dad on tomorrow, like I said, for Q&A if we still don't have a verdict by the time we do the video. If you guys have questions or if documents get sent, tag me on X, on Instagram, email them to me, whatever, and we'll still be breaking this stuff down, answering your questions. PT, what's your honestly held opinion on Cannoni's conduct throughout this trial? It's bad, but like on a spectrum of everything's going to get overturned, she should get thrown off the case, to the perfect judge, it's probably below middle. I believe that the judge said the jurors would not have access to transcripts. Is that normal? Why not? Depending on the jurisdictions, yes, that is normal. Florida is the same thing. D. Fritz, hey, Peter, shout out from Anchorage, Alaska. Been watching you every day since day one. That's awesome. JB, I didn't see the instructions. Did they make it clear to the jurors they can do a split verdict? You mean like of a lesser included? Yes. I think that they make them, and again, we're listening to her explain it. I think she does make it clear that you go down the line of lesser included. Now, if Massachusetts has this law where hung on one, hung on all for count two, then the verdict form's probably right. Peter, can you tell me, I hate that rule, but if it exists, it exists. Can you tell me why Brennan is called a special prosecutor? What is the difference between special prosecutor and prosecutor? He's a criminal defense attorney that they hired specially just for this case. That's what makes him a special prosecutor. The other prosecutors are prosecutors, right? Assistant district attorneys there. All they do is prosecute cases, not Brennan. K-Dubs, I wonder if any juror is afraid to submit not guilty due to all the cover-up and corruption, maybe fear retaliation or target. I also think there could be pressure from the other side. They heard multiple people talking about, the pressure to help Karen Reed and come in here and do something good for Karen Reed. How will that affect them? Her BAC was never checked. It was a serum test. Shouldn't that matter with all the other factors of not sure on last time, etc.? It depends on the jury, right? Or was it just generally accepted she was drunk, especially with her own statements? Sometimes that's enough. Will the investigators ever be held accountable? I don't think that they're going to go do another investigation and file more charges if she's not guilty. Peter, potentially dumb question. Could you please explain what lesser included generally means, not only for this case? So usually here's how it works. It's like you have something up top, like all men, okay? And then down here you have all white men, right? All white men are also men. They'd be included there, right? So then you go down lesser. Then all white men, maybe this is not even true, I guess, because there's all sorts of mixed races in every country now. But I was going to say like from a specific country and then from a specific state, from a specific city, whatever, right? So you can kind of work your way up, and they have to be all included to where, okay, I'm just going to prove he's a man. I'm not going to even prove his race, or I'm not going to prove what state he's from. I'm not going to prove what country he's from. I'm not going to prove this, right? So it's kind of like, maybe that was not a very good analogy, but the top one includes everything, and every step you go down, you have to prove one less element or one different element that if you were to prove this, it wouldn't automatically be the top element. So if you were to prove the top charge, you would also prove all of the lower ones. Maybe that's a better way of explaining it. So the top charge of manslaughter while OUI, you would have to prove that she was driving under the influence of alcohol first in order to get to the manslaughter. You'd have to prove that she was at least negligent. You'd have to prove that she was reckless, right? And that she knew or should have known about the issues and how dangerous this was to work your way all the way up the ladder to get to the top charge. You would automatically prove all of the lesser included to get there. That's the way it has to be a lesser included. Because if it's something separate that you would not have to prove for that top charge, it would not be a lesser included. I'm sure I just completely confused everybody, but that's my best way of explaining that. Peter, what are your honest opinions of Cannoni conduct throughout the trial? If you were the defense, would this conduct feature in your grounds for appeal? Hank Brennan's conduct would probably be number one in my appeal. The hospital even said the serum test can't be used. They didn't say it can't be used. They said it's different from forensic, and they explained some of the differences. Peter, I'm with Anthony. We can handle the haters and light work for you. Just want to know if you'll be my lawyer in the assault trials. No. Nobody is inciting any violence here at all. just nicely with logic. Beat him with logic. Jessica, if found guilty of OUI only, do you think Cannoni will sentence her to a period of confinement just because Massachusetts here in PA would get a short probation? Yeah, here, first time DUI, you would not, and she couldn't find that it resulted in a death, right? She couldn't be sentenced with those extenuating circumstances if the jury doesn't find it actually did result in that. I mean, here she would not get jail time. I have a sneaking suspicion that Cannoni would give her jail time. Steph O, do the jurors have a copy of the verdict slip in front of them while Bev is going through each charge? If not, they're probably so lost and confused. So they're usually reading the chart. Exactly what she is reading are the words in front of them. So when she's reading the definition of these charges, they're probably looking at the definition of those charges. I joined late, but is it normal that the jury has not asked a question yet? Normal, there's no normal with jurors, really. Okay, OUI verdict, 27% think guilty, 52% think not guilty, 21% think hung jury. Only 50% not guilty. That should tell you kind of how that might go back there, right? Not a slam dunk. Pizza, you were born to be a lawyer. What age did you or your dad know you wanted to be a lawyer? My dad never really knew. No lawyers in his family. He just kind of was like, yeah, I'll try this. For me, I thought I was going to be a doctor until I was in college. I kind of always thought maybe lawyer, but never really focused on it until I was in college. Wouldn't a judge want to make an amendment to the form for the better of the future and justice? New case law, doing the right thing. Is she afraid? You'd think that a lot more than you think, M. Medina. All right, let's listen to just like 5 more minutes of these instructions to continue down the lesser included, including the OUI charge.
The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent.
This is for the motor vehicle homicide that we're talking negligence. She doesn't have to intend anything.
There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or not have intended to result from her actions is irrelevant. The issue is whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well she could see and control her vehicle.
And Azam, you're noticing a lot of the same definitions, same explanations as she reads these lesser includeds. That's how it works.
The condition of the defendant's vehicle, the kind of a road it was and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The offense of manslaughter while operating under a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI liquor, and the lesser offense, and the lesser included offense of operating under the influence. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with these lesser included offenses. So the Commonwealth may prove the lesser included charge of operating under the influence, even if it fails to prove the greater charges of manslaughter while operating a motor vehicle under the influence of liquor and motor vehicle homicide. You may find the defendant guilty of operating under the influence only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are not convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide.
So she makes it clear. You don't even get to OUI unless she is not guilty of those above charges. And Medina said charges should be in chart form, always guilty or not guilty, but the not guilty first. Not guilty or guilty are the options. That's usually how we do it.
But are convinced that the defendant is guilty beyond a reasonable doubt of operating under the influence. To prove the defendant guilty of operating under the influence, the Commonwealth must prove elements 1, 2, and 3 that I instructed you on motor vehicle homicide while OUI. So the third indictment is leaving the scene of an accident resulting in death.
All right, so here is the last one that she's going to read. Joanne said 19,000 people in here and only 4,500 votes, only 245 likes. Let's get some activity going on here, guys. I don't know if that's correct, but regardless, hit the like button here. We're almost done.
Death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated a motor vehicle on a public way or in a place which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe, resulting in his death. Fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle. And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed on the first and second elements. The other four elements should be given their plain meaning, and the parties agree that I do not need to define these any further, correct? Okay, thank you.
And she's like, I've already explained all that multiple times. Do I need to do it again? No, you don't need to do it again. Okay. So that's generally the explanation Judge Cannone gives. Queen Lizzie, 2.5 in Massachusetts would be special circumstances, driving on a suspended or having kids in the car. Yeah. I certainly don't think she should get the max, right? But I could see Cannone giving her 30 days, right? Something like that, which would suck. What are alternate jurors aren't doing NA in deliberation? I don't know if they keep them sequestered or not in Massachusetts. I didn't hear what she said to them. If a hung jury on any, can she be retried for all again? Not if they check not guilty and turn it in for counts 1 and 3, let's say, but they're hung on count 2. If they check the not guilty and sign the bottom and give them to her like they should, then they should not be able to try those again. In my opinion, Karen has paid enough for drinking that night. A guilty verdict is not justice for John. She'll get credit for any days that she was in jail, for sure. But she's been out on bond for most of it. So, the suffering of having to go through all these trials, some judges may take it into account. I don't know if Cannone will. I feel that if they can't figure out the instructions on the OUI and all the lessers, they'll just vote not guilty so they don't accidentally send her to prison thinking they were voting a different way. It really depends on the juror, but I think that's a very plausible explanation and thought. Brian B., any news on the merch coffee cup? So I will say, John told me in our weekly meeting this morning that he is working on revamping the merch site, adding new merch, adding new pictures, stuff like that. It's lawyeryounknow.com if anybody wants to check it out. In Massachusetts, each charge is considered separately, and the jury can deliberate on each one independent. They are taking so long. Has anyone saw the cheek nudge to the Commonwealth on objection needed? PETA, you are the best, not guilty. I have not seen that. Casanova, does this seem intentional? A juror in the last trial cited confusion over the verdict slip as the reason for the hung jury. Stated they were only asking for clarification when Bev declared the mistrial. I totally disagree that they were asking for clarification when Cannone ordered mistrial. I just completely couldn't disagree with that more. Number one. Number two, I think the instructions were better this time. Were they perfect? Were they the best? Maybe not, but I do think they were better. Do you think the Commonwealth should have retried the case? No, I don't. I feel like we've been pretty clear about that from the jump. Ms. Vicky, she keeps saying a reasonable person. I'm a reasonable person and have driven under these circumstances. Do you think any jurors might think that? Yes, there's a reasonable person standard. It's just like how people are. Not any individual person objectively, right? They're thinking objectively, not subjectively. And everybody's definition of a reasonable person is probably a little bit different. Drunk yet an officer got in the car with her. Not only got in the car with her, but told her to drive. And a lot of officers there that night. Liz Russo, Peter, love your channel. The defense should have been able to call Michael Easter. I watched Nicole Rice be acquitted for someone similar. I definitely think they should have been able to call him as well. Annie, thanks, Peter. Keep up the great work. Just set up my own firm here in Ireland. That's awesome. Would be great to connect and maybe collaborate sometime. Irish courtroom drama just doesn't have the same flair as yours across the pond. That's awesome. Hi, Peter. How do jurors deliberate? Is there a structured process or is it free-flowing group conversation? Do jurors try to convince each other or is it rather individually decided and voted? Every jury probably does a little bit different. If you want to go back and listen to Cannone explain kind of how they're supposed to do it, but almost always they read through the charges, they read through the instructions again. Sometimes they take preliminary votes. Sometimes they talk through the charges. Eventually they start taking votes and then they talk about, they can do it anonymously. They can do it openly and they discuss their differences. They usually have questions and it's like, but what about this? Not someone like this chat. And they all try to talk to each other and convince each other of the position that they're in. And they keep taking votes until they're either unanimous or they are stuck and entrenched in a position to where they're never going to agree and be unanimous. And at that point, they're at an impasse. It's a hung jury and it's a mistrial. So we'll see. I still think there's hope for a verdict tomorrow. That's been kind of my guess from the jump. Is a verdict tomorrow. If it goes past that, then I'm going to be maybe start to think a hung jury is maybe the most likely option. I don't know. We will see. Let me know what you guys think in the comment section of this. Make sure you guys hit the like button. Make sure you're subscribed. But for now, that's all we got. Until tomorrow, we will be back tomorrow. We'll be still breaking down this case. But for now, that's all we got. Peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.